Hey there, fellow legal eagles. Today, we're exploring the intricate journey of a criminal case in the Philippines. Buckle up, because we're about to embark on a wild legal ride. Criminal complaint. So, how exactly is a criminal action commenced? Well, it all starts with filing a complaint, also known as an affidavit of complaint, to the prosecutor's office. This complaint sets the wheels in motion for what could potentially be a lengthy legal process. But what if the perpetrator is caught in the act of committing a crime? Caught in the act in flagrante delicto. When a perpetrator is apprehended in the act of committing a crime, it's known as a warrantless arrest. In such cases, the arresting officer has the authority to detain the individual without a warrant, based on probable cause witnessed firsthand. After the arrest, the clock starts ticking. Within 12, 24, or 36 hours, depending on the gravity of the offense, the arrested individual must be brought before a judicial authority for a preliminary investigation to determine if there's sufficient evidence to continue holding them. This swift action means that the trial process may unfold differently. With the perpetrator caught in the act, the evidence against them may be more straightforward, potentially expediting the trial and leading to a quicker resolution. The complaint in this case will be prepared by the arresting police officers. They will submit the complaint to the prosecutor's office. If not caught in the act, the complaint will be prepared by the complainant and submitted directly to the prosecutor's office. Preliminary investigation. Once the complaint is filed, the prosecutor swings into action, conducting a preliminary investigation if required. Now, if you're wondering what triggers the need for a preliminary investigation, it's simple. If the potential penalty exceeds 4 years, 2 months, and 1 day, then buckle up for a preliminary investigation ride. During this investigation, the prosecutor plays the role of a legal detective, gathering evidence and determining whether there's probable cause to proceed with the case. If the evidence points towards guilt, but isn't quite enough to justify a conviction, then it's off to trial we go. Complaint and information. These documents are the backbone of any criminal case, providing crucial information such as the name of the accused, the alleged offenses, date of the incident, and the circumstances surrounding the crime. Arraignment. Once the information is filed in court, it's time for the arraignment. This is where the accused is formally informed of the charges against them and enters a plea of guilty or not guilty. It's a pivotal moment in the legal proceedings and sets the stage for what's to come. Pre-trial. After the arraignment, pre-trial comes next. During the pre-trial phase, plea bargaining, stipulation of facts, marking of evidence, waiver of objections, and modification of trial procedure happen. Trial. The trial kicks off within 30 days after the pre-trial, and it's a race against the clock with a 6-month trial period, excluding allowable delays. During this time, both sides present their case, call witnesses to the stand, and cross-examine each other's witnesses. The prosecution presents first, then the defense. Demur to evidence. But what happens if, after the prosecution rested its case, the defense believes that the prosecution's evidence is insufficient? Well, that's where the demur to evidence comes into play. It's a strategic move to challenge the sufficiency of the evidence presented by the prosecution. Judgment. And finally, after both the prosecution and defense rested their case, it's time for the judgment. Within 90 days of the trial's conclusion, the judge delivers a written decision, laying out the facts and applying the law to reach a verdict. Post-judgment remedies. And what happens after the judgment is delivered? Well, that's where post-judgment remedies come into play. From motions for new trials to appeals, there are avenues for both the prosecution and the defense to seek justice even after the gavel has fallen. Let's have an example. Picture this. A concerned citizen witnesses a theft and decides to take action. They file a complaint with the prosecutor's office, kickstarting the criminal action. Now, let's say the potential penalty for the theft exceeds 4 years, 2 months, and 1 day. In that case, a preliminary investigation becomes necessary. Fast forward to the arraignment stage. Our accused thief, let's call him Richard, stands before the court to enter his plea. But here's the twist. Richard's lawyer files a motion to quash the information, arguing that the complaint is insufficient. This motion must be raised before the arraignment to avoid waiver. Now let's shift gears to the trial phase. Our prosecutor presents eyewitness testimonies and CCTV footage as evidence against Richard. However, Richard's defense lawyer utilizes a demurrer to evidence, challenging the sufficiency of the prosecution's evidence. It's a strategic move to potentially dismiss the case before defense presents evidence. Imagine Richard is found guilty of the theft and seeks recourse. His defense team files a motion for a new trial based on newly discovered evidence. This motion aims to overturn the judgment based on compelling new information that could alter the outcome of the case. And there you have it, a whirlwind tour of the criminal procedure in the Philippines. It's a complex journey filled with twists and turns, but ultimately, it's about upholding justice and the rule of law. Thanks for watching, and until next time, stay legal savvy.